if there's a breach of contract and you suffer financial loss, you can obviously claim damages. What about if you don't suffer financial loss, but there's still a breach of contract? Can you claim for emotional distress? Well, the leading case here is a 1970 case called Deason against Samson. And in that case, Anne Deason employed Burnbank Studio, based in Maryhill Road here in Glasgow, to attend her wedding and take photographs. Now, as it happened, Anne was getting married to this Norwegian guy, and so another photographer from the Scottish Daily Express was there, because a number of the guests were going to turn up in Norwegian national costume. But this guy, who coincidentally was Joe Beltrami's brother, his flashlight didn't work, so he couldn't take any photographs either. Now, because the photographer didn't turn up, Mrs. Deason doesn't get any photographs of her wedding day. She doesn't suffer any financial loss, but she's obviously very upset, and she sues the photographer for emotional distress. Now, what happened? Well, Sheriff Peterson took the view that because the contract was for her personal, social and family interests, so it wasn't a commercial contract, it was a social contract, she did have a legitimate claim for mental suffering. And the court thought that in the particular circumstances, both parties would realise that there would be distress if the contract wasn't performed. Now, Deason's quite a famous case, has been reported around the world, but a similar outcome occurred in a 1992 Sheriff Court case, Colston against Marshall. And in that case, the occupants of a caravan site, which had inadequate facilities, successfully claimed against the provider of those facilities for upset, disappointment and hurt feelings. So it's clear in Scotland that depending upon the sort of contract that it is possible to claim for emotional distress. And in England, there's a whole series of cases about people having disappointing holiday experiences and suing the holiday company. And the most famous of that is a 1973 case called Jarvis against Swans Tours Limited, which is well worth a look.